Ja, erstmal herzlichen Dank für die Einladung. Herrn Grünberger und Frau Klaas, beide. Wie schon gesagt wurde, ich bin Deutscher, ich bin aber als Jurist Brite. Deswegen habe ich mir erlaubt, als Brite vorzutragen. Das heißt, ich werde jetzt auf Englisch reden, ich werde aber gern Fragen auf Deutsch annehmen. Ursprünglich wurde mir gesagt, ich soll über die Situation in Großbritannien reden. And I took then the position that if I speak about Britain, I speak about a medium-sized country in a global world. In some ways, Germany is a medium-sized country as well, but it sits in a big economic bloc. So I will start with a kind of sketch of how the regulatory competition between the three big economic blocs between the EU, the US, and China is shaping up in the field of AI regulation and where copyright law sits in that framework. Then I will tell you a little bit about the position of the UK, kind of policy tensions between the ambition of the country to be a global leader in AI technology, and at the same time be a major exporter in the creative industries. And the governments haven't been able to negotiate that tension. And in some ways, it's a tension which we see in Germany as well. And then I will go back to the challenge at the beginning. So what are the levers available? So where can we intervene? What's the kind of portfolio of legal measures, how we can adjust incentives and revenue flows. So let's go to number one. So that's about the potential for having a science and technology policy as a medium-sized country. So the three major interventions which are currently either already on the book or shortly on the book are from China, from the US, and from the EU. You may have seen them already. The analysis today already addressed mostly the European framework. So what is important is if we analyze how these interventions work, we have to understand what are the activities we're trying to regulate and what are the legal persons we are trying to regulate. So unless we have a really detailed understanding of the technology, we can't really understand what the measures are trying to do. So one of the best representations I find is a recent published study by the British Competition Authority. So normally we just think about AI in terms of input, model training, and output. So a lot of lawyers think in kind of these three steps. But the feedback loops are the most important things. And we need to understand those, in particular if we also look for different regulatory measures relating to open source. Unless we understand really the technology in detail, we don't know how we intervene. So this, I will not say more about this, but anything I say is located in a thinking of this kind. So start with the US intervention. So the US made clear before the Bletchley Summit, so there was the big global AI summit in Bletchley Park in the UK. Just before that, the US administration released an executive order, and essentially they told the world AI policy will be made by the US. It's not a multilateral process. We set the terms. If you want to work with us, you can work with us. But we are not doing this through a multilateral process. That was the message. But if you then open the executive order, what's in there, it's long. It's long and it is fairly detailed, but it's mostly instructions to agencies. It's instructions to federal agencies. So it's not legislation, and legislation will not happen. The US has a dysfunctional government. the legal basis for the most powerful intervention, which is more than a reference to an agency, is based on the Defense Procurement Act. So the whole US intervention is based on national security, which is very important. So that is the lever the US really has. And the two compelling interventions are must share and must notify. And they're extending the definitions to dual-use models. So that means essentially everything is in scope. Every foundation model is in scope. But the obligations which will arise towards the state. So it's essentially the military-industrial complex negotiating with the state. That's the intervention in the US, and that's important to keep in mind. So we are not talking here, even though the rhetoric of the executive order is much wider, it addresses, lots of issues of bias, of privacy, of intellectual property rights, even, which I will show you in a minute. Where the meat is, where the power is in the defense. So I just copy you out here, and I won't go through that in detail, but these are the interventions which are signaled in the executive order relating to copyright specifically. It's immediately obvious that there's no teeth to that at all. It's basically, an obligation to make recommendations to the Copyright Office. It will have some influence because under a registration system, if the Copyright Office changes the criteria for registration, it affects the market. But the main play in the US, as already colleagues mentioned, will be the fair use cases. And I gave you here the four most important ones. Essentially, the jurisprudence will really set the framework under which copyright and AI will interact in the US. Okay, next candidate is China. So not many of us look at Chinese legislation in detail. So there was an interim measure on generative AI specifically, and it's in the same wave ChatGPT was released last November, so the kind of global tensions and attention to regulation of generative AI was picked up in China as quickly. So there was a consultation in April, and they published a measure in July, which then became law in August. And it's in fact a pretty sensible piece of law. I think from a Western perspective, there's not a lot in there which we would be particularly concerned about. I mean, there's something about socialist values. But what is interesting is that IP is mentioned, but in a kind of, circular way. It doesn't tell you how it's going to be interpreted. But it used to have, in the first draft, a very interesting clause. It's almost a liability clause in Professor Zech's words. Basically, there was an obligation to correct unlawful outcomes within a 3 months period. So, with severe sanctions if not complied with. And I think that's a potentially powerful tool, a potentially powerful lever. So if you create liability, unless you correct speedily, behavior of providers will change very quickly. And the liability extended in the Chinese approach, not only to the deployer, but also to the developer of the KE. Okay. So this is most familiar to the colleagues in the room. So the menu of EU interventions, at least originally, I was quite sympathetic to the idea that model training was not really a copyright relevant act at all. Extracting information from from copyright works sits doctrinally in a strange place. But I know that this is politically not an acceptable position. And also, if you look doctrinally how the EU has evolved, essentially the approach is to address any concerns through a regime of exceptions, which has its own challenges. So if you look at the precedent of the 1990s, so when the regime was formed for what we could call the regulation of the internet, the solutions globally were essentially a temporary copying exception and a limited liability, the safe harbor. So that was the debate in the 1990s. So if we didn't do that, if we didn't have a temporary copy exception, there would be no web browsing, there would be no search. So the technology, which was happening at speed in the 1990s, was acknowledged by the regulators by adjusting copyright law. So my diagnosis is that we are exactly in the same position now. So the technology has moved. The whole internet has been scraped. The models have been trained. So what do we do now? Okay, so how do we intervene? So some people might say, what Common Crawl does, or what the big AI companies, what they do is very similar to what we discussed in the 90s. Essentially, it's indexing the whole internet. And so why could we not just deal with it in that way? Again, for interpretation of the temporary copy exception in the Information Society Directive doesn't really allow that. So the route seems to be through the TDM exceptions. We've got famously the two exceptions. I've got no time really to discuss them in detail. We can come back in the discussion. And we have now the new attempt to lift the lid on training data through the transparency obligation, specifically to copyright works, in the latest draft of the AI Act. Again, I will come back to that right at the end. So I've got no time really to that's a separate talk in many ways, but what I want to suggest at this stage is just the exceptions approach, using copyright exceptions as the regulatory tool for AI poses a fundamental problem, how we conceive of exceptions. And the lawful access requirement in practice, and I speak here from somebody who's worked with researchers who try to do AI work on databases and archive material they already accessed lawfully, but they're unable to do it because the right holders which have given the license say, if you do this, we withdraw the license. Okay? So it's no good to have the lawful access requirement and then an exception if your research can't take place. So if the discretion remains with the right holder, it's potentially not working as a tool. So therefore, we need to think about carefully if we approach KE through an exception of this type. Okay. So that concludes the first, the kind of global kind of survey of the main measures, how copyright law and the development of artificial intelligence may interact. So now I come to the UK story, and this is much easier. It's basically more or less, I wouldn't say a crime story, but it's a narration. So the UK famously, while it was still in the UK, in the EU, it was the first country in Europe to introduce a text and data mining exception. It conceived it fairly narrowly because of the non-commercial requirements of the Information Society Directive. And so it was restricted by purpose, and it was also had the lawful access condition. And in many ways inspired the introduction in the Copyright and Digital Single Market Directive. So after Brexit, the UK is still looking to diverge to position the economy to have a competitive advantage compared to other jurisdictions. And one of the first interventions in the IP field was the proposal to change the text and data mining exception so that artificial intelligence companies would prefer the UK as a location. And essentially, the idea was, after consultation, the government announced that they would introduce an exception, which would have no condition of on the beneficiary. It would no purpose restriction, and there would be no opt-out. So it would be as wide as you can think about. And in the document that comes with it is actually quite an eloquent justification why that is an approach which should be attractive to the for science and technology policy in the UK. So essentially, it says here, it's hard to get licenses and it's more expensive. If you boil it down, it's just these two things. So by changing the exception, costs go down and more can be done. That's the heart of the point. And after the release of the popular ChatGPT application in November 2022, there was then an outcry from the creative industries, mostly music industry, publishing industry, and which reached Parliament, and the government decided to U-turn. So they withdraw the proposal to widen the exception, said we would think again, and then they announced with the budget in the spring of this year that by the summer the Intellectual Property Office would produce a code of practice. So the idea was, we have seen that with licenses for Europe in the past, basically you lock the right holders and you lock the AI companies in the same room, and they're supposed to come up with some kind of agreement. So money changes hands, there's a license or some kind of agreement. So the results of this are overdue. The summer has passed a long time. They couldn't announce it before the AI summit 2 weeks ago, and we expected any moment. We expect an announcement, but from what I hear is, it's been very unproductive. It's been very unpredictable. So these are the people in the room, which again is interesting. So basically, trade organizations and the major AI companies. Very little civil society. Hardly any representation from startups and SMEs. And regardless of what licensing arrangements may or may not happening in this room, we are already at the stage where licensing is happening. So, we are all familiar with, Google, YouTube doing a licensing arrangement with Universal Music, for example. So parties which are here in the room already negotiate elsewhere about access to high-quality data sets. So if they do that, those terms may not be offered to everybody, and also they're not restricted to the UK. So having essentially a licensing system set up in a closed room in the UK, there's an inherent tension that this can produce the outcomes which are promised. Okay, so now I move to the last bit of my talk. So I briefly look at what's likely to happen. What's likely to happen? What kind of interventions, changes, incentives, changes in revenue flows we might see. So my prediction is that we will move to an all-out licensed environment. We are on the path already. So essentially no model training will happen without a permission or without using openly licensed material or out of copyright material. We are moving to an environment where the exceptions don't matter. The reasons for that are essentially legal uncertainty. So while the whole internet has been scraped already, the major companies have the whole internet, as it was by, I assume, end of last year, before they got more nervous. The fact that there's a potential opt-out, which already might have been there and which now is enacted by many sites. So putting the most common tool is the robot text. So don't crawl instructions on your website. There are different modes to it. It's such as provision in the Article 4 of the Copyright and Digital Single Market Directive. So this opt-out basically indicates that what most AI companies have been doing is an infringement. So there are infringements everywhere. Okay, wherever you look, every model which has been trained has infringement in it. So that's a fact. So the question is just how do we get out of that standoff? And to getting out of that is making licensing deals. So these licensing deals are already happening. I mentioned the Google Universal one, but we also have newspapers are negotiating with AI companies. We have in the image area licenses agreements formed left, right, and center. So we're seeing an environment essentially where the big companies which have the resources and the licensing infrastructure do make agreements and for the training of models. So does that make primary creators happy? Excuse me. So one of the big worries in the creative industries, and also why many artists are upset, is that they feel violated in a kind of personal way. Their material has been taken and it's been used. So regardless of what the doctrinal situation is, there's a kind of personal resentment about what happened here. But this personal resentment will not lead to a change in money flows through these measures. Okay? So what you see as levers on the table here at the moment will not deliver. And I tell you why. So on the first one, obligation to disclose training data. There are technical issues. So the requirement in the AI Act. The requirement in the AI Act are for a summary, if you want to license, you need the right holder information for the material you need to license. It doesn't cover synthetic data. It doesn't cover ready-made models. And essentially, it takes place in an environment where these major licensing arrangements are already taking place. From these agreements, the flow of money to individual creators will be minimal. So it's you just need to look at the actual numbers. So the size, the gigabyte size of the material fed into training the foundation models, and the number of words. So for GTP 4, I believe it's 300 billion words, something like that. So that's the size of the input. So if you distribute that among creators, if you want to identify an individual book which has led to some aspect of one output, even if Google pays 2 million in a licensing agreement, what will flow to an individual creator is negligible. Okay, so the other option is, and I think that's a popular option in the German discussion at the moment, is can we move to a collective licensing system? This is offers symbolic value and will create some legitimacy for the act of training. It has also more options for steering the revenue flows through a collective management issue. It has issues which relate to all kind of levy type arrangements, and it also has issues with a digital single market perspective. So for a medium-sized country to go it alone in this global world of regulatory competition, I don't predict this will fly. The last intervention is hard to predict in which way it will influence incentives and revenue flows. We already heard that in Europe there are two directives which relate to liability, and they are not at the heart really of the regulatory debate, but the nature of the potential reversal of proof in infringement cases could make a difference for how we, what the quality of the models will be, and also where the money flows. This is an area which needs a lot more attention. So if you're interested in particularly the liability aspect, I think today on Verfassungsblog I published a longer piece with my colleagues Alexander Peukert, Tobias Kretschmer, who is an economist from your local environment, and Christian Peukert from Lausanne. So it's a interdisciplinary analysis looking at liability aspects of KE. On that plug, I conclude. Thank you.